this Tuesday, July 16th. Roll call, please.
Calling the roll, Mr. Gallagher.
Here.
Ms. Baker. Here. Mr. Tuma.
Here.
Mr. Brady. Mr. Brady's absent at the moment. Ms. Conwell. Ms. Conwell's absent at the moment. We have a quorum.
And Ms. Conwell's on her way. Public comment.
No, Mr. Chair, no one is signed in.
In your package, you have the minutes of the June 18th meeting. If they're in order, I'll accept the motion in a second.
So move.
I'll second that. All in favor?
Aye.
Thank you. Let's do 2019-0159.
Resolution number 2019-0159, authorizing a revenue-generating agreement with City of Cleveland in the amount not to exceed $771,900 for operation of the Family Justice Center for the period 6/1/2019 to 5/31/2023 in connection with the lease for space located at 75 Erie View Plaza, Cleveland.
Good afternoon. Alex Pelham, Director of Public Safety and Justice Services.
Good afternoon. I'm Jill Smiling, and I'm the manager of the Family Justice Center and the Witness Victim Service Center.
Thank you.
What we have is a revenue generating agreement with the City of Cleveland. This is a renewal that will have a contract that started in 2015. This will cover the rent and utilities for the next 4 years. As you know, the Family Justice Center is a walk-in area where people who need help, who have dealt with traumatic, violent events, they can get assistance through the justice system. This year alone, we've dealt with the highest clientele. It's the highest we've had since it's opened. It's up roughly 10% from last year at this time through June 30th. And to another great example or another great indicator is last Friday there were 11 separate walk-ins, which is very high for a single day. I've asked Jill to be here, obviously, as she is the manager, to answer any questions that you have, but we're here.
Questions for Jill? Yes, ma'am.
To the chair, to Jill. Welcome, Jill. Just wanted to know, how do you track the people that come in? And how many people have you served thus far? I know this has been since 2012? Has it been about 5?
Sure. We actually opened January of 2015, and each year we've increased the number of walk-in clients that we serve. So as you know, Councilwoman Conwell, we operate almost solely on word of mouth and referrals from our justice system partner agencies. So in 2015, we served 915 people. Since then, in 2016, it was 1,033, and then 1,011. Last year, we had our strongest year at 1,089. And as Director Pelham said, this year we're on track for about a 10% increase. Through June, we've served 534 walk-in clients. So just as a comparison point, through June of last year, it was 488. So we're seeing a significant increase. We track clients just by the number of people who sign in, the number of people who knock on our door for help.
Okay, through the chair, we assist people, connecting them with resources and stuff like that. Is the resources there to handle the individuals that are walking in? I know they come in for a myriad of reasons, but.
They do come in for a myriad of reasons. Every client is different. Every question that they ask is different. The greatest strength of the Family Justice Center is that it's served almost exclusively by Witness Victim Service Center advocates. So when someone walks in the door, the first person that they talk to is a witness victim advocate. That advocate can then access any of the partner agencies or any external partners to make sure that whatever need is there is met.
And for the victim witness advocates, I know we've had those in the past before the Family Justice. How many do you utilize? Are they all stationed there?
We have a total of 18 victim advocates as well as 2 victim advocate supervisors. The advocates work throughout Cleveland Municipal Court and the Court of Common Pleas. So any violent misdemeanor in the City of Cleveland or any violent felony in the Court of Common Pleas, any one of those victims is entitled to have a victim advocate with them. So in addition to their court-based duties that the victim advocates perform, they also are assigned to a rotation shift at the Family Justice Center.
Okay, thank you.
Sure.
Anything further? Looking at the dates, I would assume the pleasure of the administration is to move this forward.
She had a question.
Yes, ma'am? Sure.
Thanks. Thank you for your work. I just, from the beginning of the creation of the Family Justice Center, I always wondered about redundancy and overlapping between the Domestic Violence Center at the domestic court in the basement and all these other places, and wanted to know how is that working out now? With, it sounds like your numbers are up. Do you feel like they work compatibly, or I just want to see how that's working out.
Sure. So, Councilwoman, that's a good question, and I know it's one that you've asked before. We collaborate very closely with Domestic Relations Court. They send people to us, we send people to them. We're always able to help people with ancillary services aside from just doing a civil order of protection. So we can help with safety planning. Excuse me, if there are issues that are going to be before a court, we can make sure that they're connected with a victim advocate. So it's really more about that wraparound service perspective. To make sure that all of their needs are met, whether that's internal to the court process or externally. We still have strong partnerships with the Domestic Violence and Child Advocacy Center. They're on staff with us 1 day a week, and we continue to make sure that we're coordinating services with them.
Yeah, this is great. Thank you so much. It's working out, I think, better than anticipated, so.
Thank you. And Ms. Conwell is in attendance, and we welcome Mr. Miller and Ms. Simon. So, seeing no further questions, it's the pleasure of the administration. Second reading under suspension, sir.
Yes, please.
If anyone has a problem with that, I don't think so. So I'll accept the motion for Resolution 2019-0159, the full council under second reading suspension. I'll accept the motion in a second.
Second.
Motion? Second. All in favor? Against? Thank you.
Thank you very much.
Thank you very much.
Thank you.
Next, we have an update from the sheriff regarding the jail. Welcome, gentlemen. Before we start, let me preface where we're at and how we got here. Thank you for being here to start out. These are difficult times, and I know the sheriff's retiring, and I personally want to thank you for your service to the people of Cuyahoga County. I know you as a sheriff, I know you as an individual, and I know you as a man, and I have great respect for you. I know some of these questions were difficult. We framed the questions. We thought it fair that you receive the questions. We don't want to travel into areas that are legally questionable for any reason whatsoever. We don't want to impact any of the civil cases. We don't want to impact any ongoing criminal investigations. And I do know that some of these questions probably go there, but we thought at least we would have to ask these on the record. And I respect the fact that there will be some, and maybe all, that you just can't answer, but the more you can, the better it's going to be for us, to give us, the council, a roadmap as we move forward without your direction down at the jail, which I personally think will be greatly missed. And Sheriff, you have your own counsel here?
Yes, Your Honor. Your Honor. Mr. Gallagher.
Yes, sir.
Richard Blake as counsel for Sheriff Pinckney. And as you stated, we definitely do not want to have any negative impact on ongoing criminal and civil investigations. I have had an opportunity to review the 53 bullet point questions, many of which are multiple questions. It's in my opinion that none of these questions can be adequately responded to today without having a negative impact or potential negative impact on ongoing criminal or civil investigations. So as you were advised prior to this hearing, I've advised Sheriff Pinckney not to provide answers to them. And one suggestion, you can ask verbally into the record, or you can place the 53 questions into the record, however you choose.
Well, I think, and I appreciate your position. I hope you appreciate mine.
Absolutely.
But I went over the questions, and I myself, I've determined, and not being a legal person, there's 17 questions that I think the sheriff could answer.
Yeah.
So I tell you what, let's put the 53 into the record, and I will read the 17 that I think are answerable. And if they're not answerable, you'll tell me why, and then we'll move on.
Okay, fair enough.
Is that fair? Is that fair with everyone? Yes. I was going to read everything in, but we'll put the 53 in the record.
Sure.
Okay. Is everybody okay with that? You all right?
Mr. Chairman,
Yes, sir.
I have some additional questions that are not on this list.
We are not going to go outside the four corners of this document. If you wish to do that, you can call the sheriff into your committee. We're not,
No, this is an open public hearing.
and I am the chairman of this committee, and we're going to stick to this 53-question document. If you wish to call the sheriff to your committee that you chair, go ahead. This happened once before from you, and it's not going to happen again. I respect your position, and I know where you're going with this, and I actually kind of agree. But the agreement was to give these questions up front to the sheriff to be fair.
Mr. Chairman, the questions that I have are within the general scope of your 53 questions. They're not outside it. And
Let me ask, if
when you're done, if I have additional questions, I'm going to ask the questions and you're going to rule on them one by one. You're not going to make a blank statement that I can't ask a question. You're not going to do that to me.
Okay, well, I'm the chairman of the committee, and you can ask the chair to reconsider that, and the chair has said no.
Okay.
Number 3, but if there is a question, throw it out, and I'll allow the attorney to answer that. I won't handcuff your questions there.
Okay.
Beyond those issues in the Corrections Jail Division, are there any other concerns or issues that you have recognized that need to be addressed within the other divisions of the sheriff's office?
And I have advised Sheriff Pickney that, in my opinion, this could impact the ongoing investigations.
Are there any staffing changes, increases, decreases at any level within the sheriff's office today that you would recommend? If so, what are they?
Same response, sir.
What was your specific involvement in the process to establish the regional jail system in Cuyahoga County?
That's the same response, sir.
Do you think the current organizational structure of the jail is the most ideal? If not, what changes would you make to staffing to fix it? If you have changes, have you previously recommended them? If so, when? If you did recommend these changes, why weren't they implemented?
That's also the same response, sir.
As you may know, there are currently 2 charter amendments in front of the council relating to the office of the sheriff. One is to put greater guidelines around the appointment of the sheriff, and the other is to create an elected sheriff's position. Considering you have been the sheriff since 2015, which charter amendment do you prefer and why?
Same response.
That would have an effect on,
It would, sir, yes. In my opinion, the scope of what the county and what the Attorney General's office are doing involves much more than what the people in this room may or may not be aware of. And I have reviewed these. So in good faith, it's my opinion that it would have an impact.
what best practices would you like to see incorporated into rehabbing the existing jail or building a new one?
Same response.
What is the status of completing the construction rehab of the old Cleveland jail space?
Same response.
That's just the rehabbing of a piece of the building that. What is the status of completing the rehab of the old jail kitchen area?
Same response.
Okay, but I happen to know it's done, but it's not inhabited, I don't think, yet.
Okay, so question answered.
What happened to the central booking project from 2012, 2013? Would reconstituting the project help solve problems? Do you think we should do this?
Same response.
A few years ago, the county expanded the use of the ankle bracelet program. The intention of this program was for pre-trial. How many spots do we have available for the ankle bracelet program? Out of those spots, how many are currently being utilized? Out of those being utilized, how many are for pretrial, and how many are for probationary services? Would you recommend increasing the number of bracelets?
Can you give me 1 second?
We might have one.
We do not have that exact number to be able to provide a complete answer, but we could follow up on that one for you, sir.
And he's here. As a matter of fact, I probably will ask her. so.
Okay, good, thank you.
How many inmates are in the county jail awaiting trial? Out of those number of inmates, what is their average number of days in the jail?
I don't think that we have that
We can
specific answer.
probably get that from
Okay,
somewhere.
good, thank you.
What do you think the county could do to help with the overcrowding conditions?
That would be the same response.
Given that the county jail has been consistently over capacity at varying levels for years, is there an inmate population level at which you would refuse to accept more prisoners?
That would be the same response.
How do you believe the current transition to Metro Health for complete medical care has gone so far?
Same response.
Are there any structural IT modifications that still remain to be completed by the county related to the Metro transition?
Sheriff Pickney does not know the answer to that question. It's more of an IT question.
Thank you. Between the U.S. Marshal's reports and the recent State of Ohio inspection reports, what do you believe are the three biggest issues, concerns, and have those been addressed?
Same response, sir.
What are your thoughts on the State of Ohio coming in every 30 days to inspect the jail?
Same response.
What are your thoughts on why the U.S. Marshal's report was so dramatically different from the preceding State of Ohio inspection reports?
Same response.
How could those inspections have missed what the marshals found?
Same response.
Well, Mr. Miller, did anything jump off at you?
Yes, I have some additional questions. Mr. Chairman, to the sheriff, have you ever visited the Euclid Jail in person?
Yes, sir.
And Mr. Chairman, to the sheriff, was it obvious to you from seeing the Euclid Jail that it could not have a rated capacity of 80?
Mr. Miller, that would be the same response, as it, in my opinion, could potentially have a negative impact on the government's ongoing civil and criminal investigations.
Okay. Going forward, does it make sense for us to continue to contract to house prisoners for other jurisdictions while we are several hundred overrated capacity?
That would be the same response, sir.
Going forward, is it our goal that we get our downtown jail at or below rated capacity and keep it there?
Definitely.
Okay. Do we have a target date by which we wish to achieve that goal?
Unfortunately, Mr. Miller, we do not have a date, given the complexities of it and the involvement of so many parties. We, of course, everyone in this room would want it to be as quickly as possible.
Okay. What things are there that could be done at the county level that we do have control over that would be constructive in contributing to achieving that goal?
That, sir, I believe would be the same response as earlier.
What do you think can be done going forward to prevent excessive and improper use of force or other maltreatment of prisoners?
Same response, sir.
What do you believe can be done going forward to reduce the incidence of suicide and suicide attempts at the county jail?
Same response.
Okay. That concludes my questions for now. Thank you, Mr.
Does
Chairman.
anyone else have any questions? I have Ann Baker.
Yes, through the chair to Sheriff Pinckney. Is there a voluntary statement you would like to make that perhaps can give us on county council a perspective of where you stand that would not be incriminating? Is there anything that you would like to offer us?
No, not at this time.
Is that it? Yes, ma'am.
Thank you. To the sheriff and his attorney, I'm unclear about the lack of responsiveness. Is this because there's, the sheriff's the subject of a federal estate investigation?
That's not to my knowledge, ma'am, no.
So your reason for not having your client answer questions is because of an ongoing other investigation that does not impact your client? I'm just not clear why there's no answers forthcoming.
Well, I apologize if I wasn't clear earlier. In my opinion, it would have a negative impact on ongoing civil and criminal investigations ongoing at this time. And as the chairman was advised, this potentially could have been done in executive session or at a different time. And for the ongoing criminal investigation primarily, and the ongoing civil investigations, it is in our opinion that this is an inappropriate time to respond to these questions.
Okay, so this does not, the investigation isn't, your client's not the subject of these investigations. Your concern is with other ongoing investigations that do not concern your client.
Absolutely.
And on whose advice are you getting asked, not, asking your client not to be forthcoming? I mean, obviously, you're getting information from a third party instructing your client not to answer questions because of another investigation.
I assure you that no other party has instructed Sheriff Pinckney to either speak or not to speak. That is an incorrect statement.
Okay.
Anything further? Mr. Chairman? Yes, sir.
I just have to comment that I do not believe that the state requirements about executive session and the holding of executive sessions regarding pending litigation is broad enough that it would allow us to conduct discussions about the general issues and concerns and solutions of problems and how we're going to deal with things at the jail. You know, I think this is way outside of the scope of what can be done in executive session, and for that reason, I believe that there needs to be a process where the leadership of council works with you and the administration and the attorney to narrow the scope of what's excluded from, our job is to provide oversight about the running of issues of public safety as it is for everything that the county does, and the way you're handling this we're not able to do the job that we're elected to do, and that's just not acceptable. I believe that there can be an identification of a much narrower group of questions that really could have a material effect on the litigation, and that 90% of these questions could be answered. And I think we need to negotiate that out and work something out so that the council can do its job. Thank you, Mr. Chairman.
Mr. Chairman. Yeah, just through the chair. I mean, I certainly appreciate council's concern for his client, but I mean, with all due respect, you're still the sheriff. And I mean, I would imagine that there are some questions, some general questions, some of which I agree with Mr. Gallagher, I mean, that you could answer in general that wouldn't impact any civil or criminal litigation. I mean, it's a folly here. I mean, we're trying to do our legislative oversight, and we're being told that everything we ask is related to civil and criminal matters. Well, I guess we should just, turn the lights off and go home, because this was an absolute waste of time. I guess the only good that came out of this is the public can see what we're up against on a regular daily basis. And I'm frustrated. I understand, you have a job to do, sir. I understand that, but I'm extremely frustrated.
Yes, ma'am.
Through the chair to council, are you representing the sheriff on a personal basis or for the county?
I am, on a personal basis.
Okay.
Well, if there's anything that we've seen here, and again, I appreciate your position. I anticipated much of what has happened here today. But the council is always reminded we have oversight powers. Well, as a practical matter, in the open public here, I think everybody's finally realizing we don't. We don't. And I understand there are criminal cases ongoing. I understand there are criminal investigations ongoing. I really understand the civil cases that are ongoing, and I think we all do. And I know that can't be impacted. But it's a fine line between, does the public, we represent the public, have a right to know what the sheriff thinks after all these many months? We didn't bring the sheriff in because of the delicate dance that the prosecutors and some of the civil litigants were dancing and are continuing to do so. But it's a frustration on our part because we're elected to do something to find out the answers to the questions that we have, which is why we kind of knocked it down to 53 questions. Mr. Miller's request, I know, will never be granted. Any of the judges involved in this would not allow that. I understand that. That much I understand. But it only creates more of a frustration for us. And all we're trying to do is get to some sort of level of truth. And that hasn't happened. We are not just frustrated with that. We're frustrated with how we got here and quite honestly, some of the untruths that have been told to this committee and others regarding some of these subjects. So that frustration keeps building. Mr. Miller, if you have questions you want to write down and submit, we can try that. I would suggest the same answer is going to be what we had today. I thought it was in our best interest to at least try this process to get some sort of movement. And once the sheriff leaves, the sheriff leaves. And then we're dealing with the new sheriff who won't really know any of the intricate questions that we're asking. So it's really not helpful to us. Again, I appreciate your position. I truly do. But it's very difficult to sit here and hear what we heard today, even understanding your position. So unless anybody has anything further. Yes, ma'am.
me or Sonny?
Yes, ma'am.
Through the chair to council. Forgive me, I didn't get your name. All right.
Richard Blake.
Mr. Blake, yes. So if this position was, and this question is to you, if it was elected or appointed, sheriff obviously is appointed. If litigation was going on, if it was elected position, would you be able to answer these questions, or would it still be this answer that you would give?
You know what, at this point, I'm not sure if I can answer that. I'd have to give that thought, and I just want everyone on this committee to know that we share your frustration. On behalf of Sheriff Pinckney, he has no intention to stonewall this committee. That's why we had spoken with the chairman, let them know that this was going to happen. So this is not a surprise. We advised this committee that this was going to happen. If there is a way, it's a matter of timing, because you have ongoing litigation, so you have balancing interests. It's not like you're being ignored. You are not. It's a matter of timing. It's a matter of what would happen to ongoing criminal investigations to speak publicly right now. That is what Sheriff Pinckney, and that's what Sheriff Pinckney is
I think you just answered my
interested in,
question, though. I think you just answered my question. So if there's current litigation going on, whether the sheriff is appointed or elected, this could occur.
That question, I misunderstood it earlier.
Okay,
Yeah.
thank you. That's what I wanted to know.
Ms. Simon.
Mr. Chair, thank you for allowing me to ask a couple follow-up questions. And the chair states he appreciates your position, but I don't appreciate the position you're taking because it makes no sense. If your client, the sheriff, is not the subject of a criminal or civil investigation or lawsuit, there's no basis upon which your claim that he can't testify holds any weight, because any information that we glean with doing our job may or may not impact a third-party investigation that has nothing to do with your client. So I'm extremely confused about this position you're taking. If your client's not involved, then he should be free to answer questions and let the people who are involved in those investigations raise these issues. I want further clarification why your client's not answering questions if he is not subject to any investigation and/or talking to the prosecutors or investigators.
Well, I said he was not instructed by anybody.
Okay, so is he having
speak.
conversations with federal and/or state investigators?
I'm not in a position to discuss that at all.
Then why isn't your client answering questions while he's still a sheriff for Cuyahoga County?
As I've stated, it's our opinion that it will have a negative impact on ongoing criminal and civil investigations.
Why do you have a position on impacting other investigations that don't involve your client? Why does it matter to you?
That's not a valid question, ma'am.
It is a valid question.
Okay, well,
You can't answer it.
I can. It's our position.
I'm not going to argue, but your position is not valid because you should have no opinion about other investigations that don't impact your client.
Fair enough.
So for Mr. Chair, just keep that under wraps because this is not legitimate. And I think we do need to be more aggressive in getting the sheriff in here while he's sheriff to have these questions answered. They're stonewalling.
Good. Just one final question for me. Understanding that this was going to happen today, that you were going to take a position of not answering any of the 53 questions, why is it that you wouldn't have at least had a prepared statement? Something that you can do that you feel does not cross the line, but perhaps can give us something to understand what it is that we're perplexed about. So why would you come here today only to say no to everything, but not take advantage of the opportunity to put a better light on this that could perhaps give us some insight, but it's prepared in a way that would not incriminate? Why wouldn't you do that? Why wouldn't you advise him to do that, understanding that you're trying to work with us?
Well, we did answer some questions. So the statement that he refused to answer all the questions is a false statement. So let's just make that clear.
Well, let's get back to the prepared statement if that's,
We just don't have a prepared statement. We came here to respond as we were advised.
okay.
To wrap this up, Is it your position that the sheriff, if he could, would answer these questions?
He can answer questions, Mr. Gallagher. It is the determination that, given the balancing of ongoing
Sure.
investigations, not to. But yes, he's in a position where, but for those, he would have no trouble with the questions he could answer, which he had knowledge of.
If, and I've been told by our lawyers that it doesn't qualify, but if we could go into executive session, would the sheriff be amenable to answering these questions under the cover of executive session?
Again, I'd have to review all the limitations of that, but it's a possibility, absolutely.
Let's leave that avenue open. It's a slim avenue, but let's leave that open. You have the questions. I would hope you keep those. If there's a change of heart at any time or any of the verbal questions that you have, an answer in writing would be helpful and appreciated. We'll explore the potential of an executive session to get to the bottom of some of these things. But I don't know. So I've been told no, but we'll see what we can do and then go from there. Is there anything further? Yes, ma'am.
Wanted to ask you, why wouldn't county's counsel, and not us, but legal representation for the county, why wouldn't they, for the previous committees that we've had for public safety, before the sheriff was brought here, why wouldn't they tell us that due to ongoing litigation, he would not be able to answer? I mean, we've had 2 or 3
This is,
committees.
this
is the first I've heard of it.
This is the sheriff's personal attorney.
I know.
Not the county, so he's not represented
But
by.
I'm talking about when we had everyone else here. No one from administration said that due to Dave Lambert or anyone like that, that due to litigation, this is why, because I believe in that committee, you made a statement, why wasn't the sheriff here?
Right.
And no one came to us with that answer.
Yet it seems to be yet another question for the pile. Yes, ma'am. Ms. Jones?
Remind us when the sheriff's last day is. I believe he's tendered his resignation, August 2nd.
Mr. Chair, I'd like to explore a subpoena, or you're working cooperatively with the sheriff and his attorney, but I'd like to see if we have the option of subpoenaing the sheriff in before he leaves with real legitimate defense, and I want clarification.
We can subpoena, but he's here, and we can compel his presence, but I don't think we can compel answers.
You can't.
And I'm not a legal expert, but I think that's a slippery slope.
I don't know if it's slippery, it might not be effective, but what we need to do to get some answers.
Well, there's no question that clearly we're struggling for a way in which to accomplish what we think we need to accomplish. So if you'd be open to further discussions regarding executive session, I think, to me, that's the only way right now we have to go. So,
As was discussed at the beginning.
Right.
That was
And
always
I-
the options. Sheriff Pickney is not looking to withhold information. That's, I'm going to be very clear with that.
I understand. Okay. Yes, ma'am?
Recently passed an ordinance, 2018-0013, that said that when we have questions that go unanswered, that the road leads to the executive. And the executive then can appoint a designee, if he would like, to answer those questions. And there was 30 days to do so, along with parameters of how that question was to be answered. So I don't know if that applies, that if we can enact that piece of legislation to bring the executive forward, if the person that is the person we would like to get those answers from is unable to, then the next step would be the executive who is in
Well,
command.
we have, that's again a slippery slope. I think we now have staff attorneys, we can run that by them. But I think this is a moment in time for the sheriff. If we have direct questions for the administration, there's nothing stopping us from bringing the executive down. But considering the state of affairs that we find ourselves in as a whole, I would imagine we'd be getting the same responses.
Just wanted to bring that to our attention, that we did pass that, wasn't very long ago. We worked on that for about 4 or 5 months, making sure we knew what the parameters were. And
Have to do, the concern I really have is that there are ongoing investigations, I would assume civilly and criminally, we don't know about.
yeah,
There are criminal indictments that we do know about. So it's like a walk in the dark. We see a light, we're going for it, but I don't know if we're going to stumble into something that's going to change the course of our path, or the path of the county, or the path of justice. And I don't think we can get in the way of the path of justice. So we'll discuss this with our in-house attorneys and the county attorneys, and if there's a possible way to have the sheriff come in and be more forthcoming.
Without question,
We'll
without
figure
question.
that out. Again, thank you, Sheriff, I appreciate it. Anything further?
Thank you
And
all.
you have the questions,
I do.
and
yes.
then
Thank you.
we'll write up the verbal questions that were asked also.
Perfect.
So you have
Appreciate it.
those. Thank you. Well, again, to finish that off, I hope the public has a bird's eye view of our bird's eye view. It's difficult to inflict oversight when we have no ability to compel answers to questions that I think are legitimate, fair, and above board. And I appreciate, again, I really do appreciate the fact that there are ongoing investigations and that there are people that have been indicted, and they deserve their day in court. Everyone's innocent until proved guilty, and I guess we'll stay with that. That's a tenet of our government that we're going to have to appreciate. But we will discuss in-house with the attorneys as far as executive session. Can we do that? Okay, gentlemen. Is Euclid here? Did Euclid come in? Did somebody, Ms. Carney, did you speak with the folks in Euclid?
Good afternoon, Council. Brandy Carney, Chief of Public Safety and Justice. Yes, sir, Councilman, I did speak with the city of Euclid last week. We reached out and had a meeting, myself, the jail administrator, Rodna Gibson, the associate warden, Kevin O'Donnell, have met with their administration, which included their mayor, their council president, their law director, and their police chief, and had expressed that the discussion has been going on for some time regarding the Euclid jail location, but the decision had been made to no longer keep that location. They were understanding of the situation that we're in, but they did express obvious concerns about what that leaves them. So we went and met with them last week. We did give them all of the different options that would be available for them as a city, meaning they could turn their jail into a full-service jail, for example. They could move into a 12-day holding facility. They could house their prisoners completely somewhere else, so different options discussed. Following the meeting, myself and the jail administrator both sent them documentation on those options as well as requirements for each. They were going to read all of that information, and we have a follow-up meeting scheduled for this Thursday afternoon. We did commit that we will work with them and identify a plan with them and a timeline. We would like to see it as soon as possible, but nobody would ever put them in a position where there's a public safety concern on their end either. So we left that meeting, and that's where we're at, and that the follow-up meeting with their administration and police chief is this Thursday afternoon.
Okay, so that was after our Tuesday meeting when the council basically found out through a published story in the Plain Dealer.
Yes, Councilman, we met with the city of Euclid on Thursday afternoon. I had reached out early in the week to the police chief, but obviously we don't want any of our partners to find out something through media. I can say
I
we
just-
also, oh, sorry.
I just wanted to make sure you heard me.
Yeah.
after our meeting last Tuesday, the council found out in a published story in the Plain Dealer. Ms. Simon, you want to take it from there?
Thank you, Mr. Chair, and found out as well that there was a problem with the Euclid Jail after it was published. And representing District 11 in the city of Euclid, I can tell you that the city has relied upon the county to provide the jail service, and their budget reflects that. And without a plan and a way to accommodate this, there will be a public safety issue in the city of Euclid. But I'm confident that working with the partners that we'll be able to come to some remedy for this, because they don't have a jailer, they don't have a budget, they're not in a position any longer to operate a jail, and I am not going to let them just stand there holding the bag with, you know, how to manage this, and not to mention the city of Bracknell, city of Richmond Heights have been using this jail, and you know, to close the doors down is really going to create a hazard. But we're going to continue to work to make this happen, but I'm not going to sit here and allow them to be stuck holding a bag without a plan from the county that represented that they'd be able to assist with the regional jail, and we've got to find a way to make this happen, whether it means transporting prisoners to our central facility as an option, and we'll go through that, and I will try to be at that meeting as well in the next 2 days. Thanks, Mr. Chair.
The fact that Euclid's not here, I guess things have been smoothed over. The whole thing is that, you know, communication's an important part of this. We were not part of it again. We yet again extend our hand to the administration to let them know that we're here to help them, not hurt them. It's been 5 years now. Reach across, grab the hand. Ours seems to be the steadiest here, at least in the past little while. And these things impact our various districts, and everything's a domino. So I understand we're going to have major discussions further on Euclid, further on Bedford Heights, further on Cleveland. And as I told the administration, this is not an issue of this administration. This goes back in time when this council was told things that were not true, or we wouldn't be here. So we're going to have to find some things out, like how we went from 80 to 32 beds. Somebody knew that, so we'll try and do that, unless somebody claims they can't answer that too. But we'll try. We're going to do our best to get there. And I know this is not an issue that you created, nor is it an issue that anyone, I think, still here created, but it's an issue that we have to address, and we have to be delicate in the fact that we have gone to other cities to take their prisoners, and in just a remedial business sense, we owe it to them to do the right thing. And I anticipate that we will. Some tough discussions and more tough decisions are down the line. I've looked at October as being probably a go date on some of these things, as I told the executive, and I know he's been brought up and he's concerned also as to where we're at. So hopefully collectively we can move forward. Yes, sir.
Mr. Chairman, and to Ms. Carney, and first I'll say that I totally support the notion that we have to do right by the city of Euclid and by the other communities, because we dragged them into it, and now we need to help them get out of it. So I totally agree with that. But I also have to say that as members of the county council, our responsibility is for county government. And we have dug ourselves into a deep hole. We are housing prisoners on behalf of several other communities at the same time that we're running a jail that's several hundred prisoners over its rated capacity, and you just cannot run a safe and humane jail under those circumstances. And the first rule, when you dug yourself into a deep hole, is to stop digging. And what I'm saying is that we need, and I'm asking the chairman to help with this, and he's indicated that he's already started this process, and I support him on that, and I'm just basically offering reinforcement. But we need to do a comprehensive review of our entire program about housing prisoners for other communities, and we have to determine whether or not going forward we can do this at all and operate facilities that are safe, humane, and within rated capacity. And I think it's very important that we do that before we make any further lasting commitments. And so I just appeal to your help with that, and to Ms. Carney and to the administration to and I'm not blaming anybody for this. All I'm saying is that we have to recognize that we can't keep doing what we've been doing, and that we have to say what is the best way forward, and we have to be willing to make difficult decisions and to make meaningful changes so that we can get this right. Thank you.
The good news with that, Mr. Miller, is we have the committee for the Justice Center Jail. The folks that were hired to program that and take us through the process are nationally renowned and are in the process of doing just that right now. They're speaking as we sit. They're speaking with the judges, the jailers, the sheriff. Everybody's involved in this, and we'll get a comprehensive report on just what we can and can't do. In the meantime, as many people in the justice system have said, is the central booking is a central part of cleaning up the problems that we have in the jail. 30 years ago, that was important. 20 years ago, that was important. 10 years ago, that was important. Yesterday, it was important. We're still not there. That's not us. We can't force the justice system within Cobb County to move. We can provide the funds and the manpower to do this, but we have to have the will from all partners involved. I know those discussions are ongoing, but they're just discussions as they were 30 years ago. That is an absolute positive key to cleaning up, I think, what we have here as far as the mess in the jail, as far as overcrowding.
Mr. Chairman, given the history of mass incarceration in the United States in the last 30 or 40 years, I just have to restate my reluctance to rely on experts in making these decisions. Obviously we got to hear what they have to say, but I think that we're going to have to accept the responsibility and make our own decisions about what's right for Cuyahoga County, given what we know about criminal justice and patterns of discrimination and inequities in the criminal justice system. We're going to have to do something that's forward-looking and not backward-looking, and that we're going to have to take the responsibility to hear what the experts said, but also exercise our own judgment as the leaders of this community, and not just rubber stamp some report because they're the experts. I just know I'm not willing to do that. I'm only one of 11, but I I just want to put that out there again because I think it's so important. Thank you.
Well, that's the intent, and hopefully that's where we get. And if we have new facilities or redone facilities that are like new, hopefully the mindset is likewise new and forward-thinking. Again, central booking is absolutely positively a must, and we're behind the times, way behind the times on that. There are a couple questions that Sheriff couldn't answer that I thought maybe you could. Ms. Carney, you weren't here in 2012, but there was an attempt on central booking. You don't know where that went?
Unfortunately, I
Yeah.
don't have knowledge of that discussion in 2012, sorry.
The ankle bracelets. Now, that was for pre-trial, and it was kind of hijacked for probation. Months ago, we found that out. Has that been stopped?
To the council, or to the chair, excuse me. Unfortunately, I just saw those questions right before this meeting, so I wasn't able to prep for some of them. Based on my knowledge, last time I looked, we were at approximately 300 GPS bracelets, and we were doing an increase of 50 bracelets, so there was approximately 350 bracelets being used. When I was monitoring it somewhat regularly, there was, seemed to be close to 50-50, whereas.
It's not a 50-50 program.
Pretrial versus probation, and
It's not meant for probation.
I can tell you, Chairman, that you guys had brought that up in committee before, and I had relayed that, and there were differing opinions of the past and when at the onset.
Well, I'm not looking for opinion.
Yeah.
It's not the opinion of anybody in the Justice Center. It's our opinion. We're paying for this. It's our program. We've given the money. We've bought the bracelets. We're providing the service. It's for pretrial. And you have to step up and stop this, because we'll cut the money off. We'll pay for pretrial, and they're on their own on probation. We're not a probationary function here. This is for pretrial. These are beds that could be made available.
If I could, Chair, I absolutely had moved forward when we discussed this in the past about the pretrial notion. I would just say, in discussing with the courts at one time, they had stated that if they're using it for probation, they're using it because otherwise those people would be in the county jail. So it's not like they're using it, they're using it as a method to save on bed space. But that was a response. I did have them separate out and start sending me pretrial versus probation. So there was a distinction. It was about 50-50. But there were a few positions that used it significantly more than others that there were discussions. So we can continue to follow up on that.
I think they're fudging there. And I understand it's easier to put somebody on a bracelet while they're on probation, but that's not the project. That's not what the money was for. We need to kind of concentrate on the pretrial, which opens up the beds. And if somebody wants to put somebody in jail that they were willing to put on a bracelet, but unwilling, to leave out in the community, so be it. So be it. But the pretrial is what it was for.
I can tell you, sir, that, I wasn't here when that discussion, and not everyone recalled it that way, but I will make sure to follow up again following this discussion and continue, because I agree we need all the resources we can for pretrial
Right. And if
jail
it's
space.
helpful, we can discuss moving forward on a different program with probation. I mean, we could do that, but that's extra work for those folks that are watching these people on the screens in the Justice Center or the Juvenile Justice Center that are on the ankle bracelets, and it's a tax to them. So it's a dangerous situation if you don't have that manned up.
And if I could, there's also, they're in the sheriff's office, not just the juvenile justice, but the sheriff's office provides the GPS monitoring for the bracelets too, so it's not just,
Well, if we
it's
have
their
to have-
staff also.
If we have to have that discussion, let's have it. But for right now, it should be pre-trial, not
Absolutely.
probation.
Let me
If
collect
the
the data
judges
for you.
want to talk about probation, we can do that. And that's helpful also to loosen up those beds.
Mm-hmm.
But, we've got to keep the money going where it was intended. That's all. No? Makes sense?
Absolutely makes sense, thank you, sir.
Can I ask one
yes,
quick
ma'am.
follow-up to the bracelet issue? So if the judges are not inclined to utilize the bracelets for pretrial versus probation, what do they do? Just sit in a closet?
So.
That's a
Chair,
question.
Yeah,
Yeah.
I would say that they are being used, the bracelets are being used. When I had asked why they all weren't pretrial following it coming up previously, the response was that it's about 50-50 pretrial and probation, and
I understand, but the chair rightly is asking that these bracelets be used only for the purpose for which they were intended, which was for pretrial, not probation. So if we take all these bracelets and put them over to pretrial, and the judges, arraignment judges, don't want to use them to the capacity, I want you to find out then what happens. Do they just sit there in a pile? I mean, if we're only using them for this purpose, which is fine, we should be. I want to know if they're not used to the full extent, then what?
Sure.
Is there a way to do like a library, a loan, over to probation? That's the kind of thing I want to get some
Understood.
answers to, if that's okay, Mr. Chair.
understood.
Okay, yes, sir.
And my concern is for the individuals who are sitting in jail, if they are, before you receive the ankle bracelets, if they were released by the court, but they had not been released by the jail because they didn't have an ankle bracelet, as was said to me in certain cases. And you can tell me if you've heard that as well, that there were individuals who could have or should have been released, but were not because of a lack of ankle bracelets.
Well, yeah, they're using them for probationary purposes. It's not like they're sitting around, I can tell you that. They're all being used.
They are being used. I hadn't heard specifically someone tell, for example, that you would be out except for we don't have, but I can follow up on that, sir.
the
But they are
follow
being
up on
used,
that.
yes, sir.
Because obviously that would not be a good situation if that were the case. So that is what I heard, but it's just, so I'd like to know that.
It's a reasonable, to follow his conversation, it's reasonable to assume that there will be people out there that could be pre-trial ankle braceleted that can't be because there's probationers on there. And we have to separate that, and we'll have discussions. I mean, it's something that works,
Absolutely.
so let's split it into work as opposed to, having folks in jail that could be out, and that's a bed. This all leads, I think it's a practical matter to do this, and we're more than willing to discuss it with the courts. So if you would share that and move forward with it, let us know.
Sure, absolutely. We'll collect the information again and share with court again and maybe send a memo, but absolutely, sir, follow up.
And Chair, if I might be able to finish my question? Sorry. So, and only if that was the case, and the ankle bracelets are not being used, the risk is possibly to have someone incarcerated, held, who, if they were to lose their life, that would be a difficult situation, to have a loss of life with someone who could have potentially should have been released. So I ask that we follow up on that.
Okay.
Thank you.
Okay. An interesting day. Thanks for being here. Thanks for your questions, Mr. Miller. You were right. I was wrong. More questions were good. Maybe we'll get answers to those. I hope we can do something to get more information to the council so we can do our duty. And thank you for being here. I thank the sheriff for being here and all those that participated, everybody for your attention during this hearing. I think it was very important, at least for us, to show the world what we do and how we do it and some of the roadblocks that we run into. Okay.
Thank you,
Anything-
counsel.
No miscellaneous business? Thank you.